Mr. Walker continues to report as directed. He still continues to report Social Security as his only means of support besides support from family and friends. And as of today, $828 has been paid towards restitution.
For 5 years? Since we've been in this 5 years?
Just to correct, I think there was an appeal that went after the trial, and I think he's been on probation since October 22. Is that right?
That's correct.
2.5 years.
2.5 years.
Okay. Well, the probation order was signed on November 16th of 2019.
Yes, sir. But he did appeal.
When the court rendered sentence.
Wait, did you hear that? 36,000 years. At this pace, he'd still be paying restitution long after humanity settles on Mars. So here's the real question. Is this insane number a flaw in the system, or a clever tactic by the defendant? What's your take?
It's based upon the jury verdict, and then that was all held in abeyance while the defendant appealed, which takes a long time. So we're talking about, what was the date you said?
October 10th of 22. I believe that's correct. Mr. DeGarren's welcome to correct me.
Okay, so we're 2 years and 3 months, 27 months into this, and what's the bottom line? What do we have net received from the defendant?
Net received.
Total. And then we'll work from, because it was primarily going to go to restitution, correct? That's what the court had expressed. But there's some other fees that the state just rolls into a judgment that.
Total credit, $2,488.
I'm sorry, say that again.
The total credit.
Yes, ma'am.
Paid in $2,488.
$2,000.
Yes, sir.
$488.
$88. $60 per month goes to the supervision fees, and whatever else is paid goes straight to restitution.
Oh, okay. Okay, so, and what is restitution balance now?
$1,171,828.01.
Okay, the figure being the defendant on active probation, well, from the finalization of appeals, 27 months, and at $2,488 being totally paid, that averages $92 a month. And when supervisory fees are paid, that's a grand total of $32 going toward restitution, which would take him about 1,000 years.
Now things are heating up. Bankruptcy dismissed for non-payment of fees. That's huge, because bankruptcy isn't a free escape hatch. You've got to prove you're broke and follow the court's payment plan. When Walker failed, it didn't just kill his case, it shattered his credibility and exposed a paper trail of assets. And trust me, that trail is about to haunt him.
To pay this off. Does everybody see the math doesn't work? About $384 are paid a year toward restitution, which at $1,171,828 total, he could pay it off at this rate in 36,000 years. So that's not working. So, but I've looked what is being presented to this court on financial is, according to the defense presentations and the probation, is that it's very limited on what he receives from what little amount he claims he earns. Most of the monies are that his income is based upon is from family and friends.
May we weigh in?
Unless, you're going to be able to articulate anything that this court can get more information on so that we can figure this out. Because this is an impossibility, but this court is going to note, Mr. DeGuerin, that we have a lot of people who are on probation who are paying restitution, and this Mr. Walker is sticking out as one of the very few who pays such a small amount. Why is that? Because the answer is, I don't want to hear about it. He has capabilities. He has earning power. I know it's limited with a felony conviction, but there are a lot of people who have felony convictions in this court who are paying monies, and it may not be $1 million, but they are paying substantially more than what Mr. Walker produces. And I'm not the one that follows him around to check on him to see, you're not working. I'm not going to do that. I can't do that. I'm going to have to rely on the probation office to do their job with the other thousands of cases that we're handling at the probation that we have to deal with. But if the state has some information that can help this court get to the bottom of this mystery of how this can get paid back under these circumstances, I'd like to know. So go ahead. Give it your best shot.
It is the state's position that the defendant has numerous properties, and both personal and real properties, that he was actually told to sell by the probation department, which was brought up in the hearing of October 23. Mm-hmm. If the court will recall, late last year, we became aware that he had filed bankruptcy, and the court was interested in knowing what happened with the bankruptcy. We have inquired in the bankruptcy hearing and the courts, and we have been informed that it was dismissed.
Hold up, a GMC Denali, a Jeep, a Cadillac Escalade, and a mystery car worth 20 grand? This doesn't look like a man struggling to survive on Social Security. It's starting to smell less like hardship and more like creative accounting. So tell me, what would you sell first, the Denali or the Escalade?
December 6th of this last year.
Why was it dismissed?
Because he wasn't paying the agreed on fees that he had.
So he's no longer in bankruptcy.
He's no longer in bankruptcy. However, inside the bankruptcy records, he filed a sworn affidavit about as to what properties he owned, and he listed all his properties. And we provided a copy to the defense, although I suspect they already had it. The courts provided a copy to the probation department this morning or this afternoon, and I'd like to provide a copy to the court.
Do you have this, Ms. Hunter?
I just gave it to her before we started.
Okay. Looking at this one for the first time.
Yes, sir. I've tabbed, and it is signed under oath. It was signed by electronic signature, and under the penalty of perjury in the federal courts. I understand they take that seriously.
Okay. First of all, Mr. DeGuerin, does Mr. Walker have real properties that he owns?
My understanding is that they're jointly owned between him and his wife that he can't sell.
Why can't he? I mean, why can't he divest himself of his share, his portion of the ownership? Because just a joint partnership doesn't exclude somebody from being responsible for that portion of the monies, and unless it's a homestead, and I don't think you can claim more than one.
Under the documents he filed, he did not make such a claim. I wish to add that the information that's contained within his sworn affidavits or statements to the bankruptcy court are in direct conflict with what he was telling your probation officer. The total amount of assets that he's claimed to have at that particular time, $996,000, of which non-exempt was $485,000, which could have been liquidated immediately, which included real property, numerous properties, numerous vehicles, numerous work vehicles, and all these things that he tried to use to allow himself to be in bankruptcy, which he did not inform this court, despite the court repeatedly requesting that he provide this information, because it's all designed for him not to pay the restitution in this court. And from the state's perspective, we've had enough. And we feel maybe it's time that we file an MTRP and we litigate this, him not paying his restitution, because we do believe he has the ability to pay it. At least make a good faith effort. Right now, the amount that he's paid is a mockery of this system.
Judge, may I add?
Yes, ma'am.
I did ask Mr. Walker for a copy of the bankruptcy hearing, and I did not receive it until I just received it from the DA. He did not provide a copy of it.
When did you ask for it?
In December.
What took so long? What took so long to? This lady works for me, and she speaks on my behalf when we need information. What took so long?
You told them last hearing, I want all the information that's being provided for the bankruptcy purpose that we don't have, so that Ms. Hunter can get that to me. We need to know all sources of income, sir. You said that directly to these two last hearing.
What about that? What about that from the defense?
Seeing some of this for the first time, but it looks like on January the 21st, Mr. Walker provided the probation officer.
What was the date that I ordered that, please?
November 15th of 24.
Think you got around to it timely?
You have to collect the document.
You think you really? I know finances. I got finances. I got to deal with it. But this is a court order. It took you 2 months. Is something more important than this?
Are you speaking to me?
Both of you. Yeah, I'd like to know, because some of the court's orders or seem to be lackadaisically followed or not followed at all. I wanted that. Well, I thought that would be timely, but now we're 3 months past that date, and I'm just finding out about it. Shouldn't I be concerned? Go ahead.
If you look at the documents, those are two different documents. The one that I forwarded to you is different from the one that I received from Mr. Patch.
In what way?
The first one that I received from Mr. Walker is from 2023, but I received the results from Mr. Pat today. So it's two different.
Well, I want whatever's updated. I mean, things may change over time. I just wanted updated amounts. But what don't you have from him right now, Ms. Hunter?
Well, I received the bankruptcy info from Mr. Pat, and he emailed the letters of support. Mr. Walker emailed the letters of support to me this morning, but I have been asking for those letters since December.
Since December?
Yes.
That's 2 months. Those things need to get in there as soon as possible. But you have this bankruptcy matter. It looks like y'all dealt with that thoroughly. When was all that filed? These documents that the state has given to me, when was that material filed in the bankruptcy court?
I don't know when it was exactly filed. He signed it, according to this, on December 1st of 23. So the information that provided all this
that's
property.
over a year ago.
Yes, sir.
I'm looking at what has been given to me on this bankruptcy, and this is executed on 12/1/23 by the defendant. And Describe each residence, building, land, or other real estate you owned or have an interest in, beginning with.
And there it is, the bombshell moment. Nearly $1 million in assets, yet barely $2,400 paid over years. This is the kind of revelation that flips a courtroom upside down. The judge now isn't just questioning the numbers, he's questioning integrity. So here's the big question for you. Is this incompetence, deception, or a strategic attempt to dodge accountability?